The U.S. Supreme Court has issued a directive to the SEC in response to Ripple's appeal, pointing to specific XRP actions. Based on the decision, the appeal process would be rendered invalid if the SEC did not fulfill certain requirements. Ripple must now react to the decision, which entails Citibank disproving Ripple's Brad Garlinghouse by focusing on the world's most powerful individuals, in response to comments made by crypto executives claiming to have fresh evidence regarding Operation Show 2.2.0. Everywhere that people can buy Bitcoin, a particular XRP market action has been identified by the court as the cause of the present surge in trading volumes. Despite the headlines suggesting that this event is the sole source of the spike in XRP volume, the court has singled out this action anyhow. Because absolute is not true, it did not move. The amount of XRP trades has reached 1.26 billion or 2.43 billion XRP, according to information from CoinMarketCap, even though total passion did not drive the movement. In IDs, this sum is worth 42.29774 at the present time. In regard to the present appeals process, the Securities and Exchange Commission has requested that the deadline for delivering its substantive brief be set between January 15th and January 25th. Any significant change in the volume or price of a cryptocurrency is thought to have its origins in a shift in the market. Cryptocurrency price fluctuations and news stories about breaking events occur frequently. There is constant coverage of breaking news articles and fluctuations in cryptocurrency prices. The correlation between these events is not valid, even though news stories about cryptocurrency price fluctuations occur frequently. So, the point is to get people to agree that absolute is the right choice. The 7-day XRP price and volume chart shows price as a green line and volume as a mountain in the background. If the price is higher than the mountain, then the green line is higher. There is a correlation between these two variables, but the strength of it varies among coins. The association remains regardless of the coin in question. An obvious example of this can be seen in the wild price swings that Bitcoin experienced all at once. This movement included both positive and negative shifts. The courts have reached significant milestones in the ongoing appeals for Ripple securities. The second threat letter sent to the SEC contains a warning. Both of these things helped Ripple's case against the US SEC a lot. The court has issued new directives to the SEC. Based on this trend, it seems that the market volatility could be caused by factors other than the SEC's actions. A new court order has been issued as a consequence of the CC's appeal against Ripple. Not only did the court issue the directive, but this verdict has shed light on the ongoing legal battle between these two firms, which are the most well-known Bitcoin exchanges. Aside from the prospect of more government regulation and oversight, people all over the globe are concerned about the Ripple case and its potential effects on cryptocurrency markets. The appeal is due on January 15, 2022, as requested by the Securities and Exchange Commission. Because of this request, the Second Circuit has given the SEC until January 15, 2025 to submit its appellate briefs. In a ruling dated October 31st, the user's request was approved by the Second Circuit Court. The Securities and Exchange Commission has a history of putting off filing documents until the very last minute, even in 2024. Rather than a genuine delay, this is an attempt to make things more difficult for Ripple. The market has concluded that the SEC has not achieved its goals in relation to anything that presents a substantial opportunity for speculators such as Ripple. The court has threatened to dismiss the case if the appeal brief is not submitted by January 15, 2025 by the securities regulator. This warning was issued while the work was being preserved. An attorney by the name of Bill Morgan has made a statement stating that the consequences of failing to meet the deadline are very evident in this specific case. Another significant event in the Ripple case that occurred as a result of Brad Garlinghouse, CEO of Ripple, is the danking of Citibank. This occurred after the two companies had done business together for a number of years. Garlinghouse experienced the loss of Citigroup services personally because he had relied on them for years. The U.S. corporate sector, he said, is struggling to maintain banking partnerships in the wake of government warnings that institutions should reduce their Bitcoin participation, and his personal experience is just one example of this trend. However, he was able to draw this conclusion by comparing his personal experience to the larger trend. After the fact, Garlinghouse made it public that he had been cut off from all communication by Citigroup Inc., with whom he had done business for nearly 25 years. However, Citigroup Inc. recently severed links with Garlinghouse. Allegedly, Dringhouse told CoinDesk that the government is preparing to penalize financial institutions that have severed ties with banks because of their involvement in cryptocurrencies. Plus, he came clean about the fact that he has lost personal money multiple times due to his involvement in the Bitcoin industry. He went on to say that he has cut relationships with other individuals. The present status of affairs is supported by multiple pieces of evidence. He was given 5 days by the court to transfer the funds. This was conveyed to him by the court. The CC has drawn criticism from investors and the public at large for failing to submit its appeal brief by the specified deadline. The ongoing Ripple case has brought attention to the challenges the SEC has in maintaining its regulatory authority, and the court's decisions have prompted federal authorities to investigate the matter more thoroughly. Choke Point 2.0 in operation is an official government program that has run for about 7 years is detailed here. There has been a lack of coverage of this type in recent news reports. I seriously doubt that Dringhouse would come up with such a ridiculous story. Even though the existence of Operation Choke Point 2.0 is beyond dispute, Coinbase's chief legal officer Paul Grewal maintains that the public deserves to be informed about it. Financial institutions have been instructed by the Federal Deposit Insurance Corporation to either stop offering crypto banking services, stop marketing them altogether, or not move forward with the delivery of such services in more than 20 instances, as reported by Graywall. This has been brought up previously, so it must have been a genuine event. He thinks the public should be informed about what's happening, and bureaucracy is an excuse for the Federal Deposit Insurance Corporation to not do its job. The author maintains an optimistic view of life because, in due time, events will demonstrate that average people can earn money to improve their quality of life. No adult should ever be forced to follow a government order, no matter how risky it may be, especially when dealing with volatile asset classes like cryptocurrency.